My job is to introduce the last speaker of the day, Professor Bob Raines from Pennsylvania State University, as you can see, Dickinson School of Law. Bob's with us for a week. He's got a sabbatical this year. That's something that people get at other universities to do research. And he's spending some of the time in England. He did come here to a family law conference that Martha Sampson and I organised some 5 years ago, and we are very flattered that we are one of 3 places he has chosen to visit whilst he's here, the others being Cambridge University and London University. So, Bob is a law graduate. He did his JD, called in the States, at Harvard Law School. He is a family law, juvenile law, and disability law expert at the university. He teaches in those areas, directs the disability law clinic, and co-directs the family law clinic at Penn State. He also, given the different system in the States where academics are also practitioners, he also represents broadly as a Mackenzie person or various people, even up to the United States Supreme Court. So I won't go on, but I wanted to give you a flavour of how lucky we are to have someone like Bob talking this afternoon. So over to you, Bob.
Thank you, Roger. You're my guinea pigs this afternoon because this is my first run through. This is a paper I have just completed writing on same-sex divorce in the United States, and the subtitle is "The Only Thing Harder for Gays and Lesbians Than Getting Married in the United States." Now, as you may know, in the United States we have fractured family law. We have 50 states. Each one has its own marriage law and its own divorce law. And the states famously do not agree with each other. So think about that. 50 different jurisdictions, 50 different sets of marriage and divorce laws. And how they intersect becomes extremely complex and sometimes very controversial. Now, this is a quick geography quiz. Have I left anything out here? What is missing from this picture? Please? Oh, someone said Alaska. Yes, there she is, waving goodbye to her duties as governor, no doubt. And the next slide is a typical native Hawaiian. We think he's a native Hawaiian, vacationing at home. And I think you know who that gentleman is. And I focus on Hawaii because there had been in the United States, over the course of about 20 years, several cases around the United States where same-sex couples sued in state court for the right to get married. And for roughly 20 years, those cases were just tossed out summarily. No right, no right, no right, no right. Go away, don't bother us. And that remained the situation until the Hawaii Supreme Court decided the case of Bear versus Lewin. Now, every state not only has its own marriage and divorce law, every state has its own state constitution. All right? In Bear versus Lewin, the Hawaii Supreme Court says that same-sex couples may have the right to marry under the Hawaii state constitution, and remanded the case for a trial. Now, that was the first time that any appellate court anywhere in the United States suggested that same-sex marriage might be a right. Now, what was the political and social reaction around the United States to Bear versus Lewin? I think it said that a picture is worth 1,000 words. you may be familiar with that particular painting. The Scream. Bear versus Lewin set off a chain reaction in the halls of Congress and throughout the United States. And we're still seeing that chain reaction play itself out now, 18 years later. The reaction of the United States Congress was something that we affectionately refer to as DOMA, the Federal Defense of Marriage Act. A very short act as federal laws go. I spent a lot of time reading our Social Security Act, which is 800, 1,000 pages long. This is 1 page long. DOMA says, this is federal law, no state is required to give effect to any public act, record, or judicial proceeding of any other state respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state. Translated into English, Congress says that if a same-sex couple gets married in state A, state B does not have to recognize that marriage. It can, but it is not required to. Now let's think about that for a moment. And I think most of you have not taken family law, if I'm correct. What's the normal rule of being married? Well, the normal rule of being married is what we call in Latin, for all of you Latins, lex loci. If you're properly married in the state where you got married, and state could be a country, then you're married everywhere. You're not married in one place and not married in another place. My wife and I got married in Pennsylvania. She would think it would be rather odd if I could, say, travel to Michigan and by virtue of going there, no longer be married to her. And by the way, that would be very bad for family lawyers if you could simply get out of a marriage by traveling to a new jurisdiction. So the general rule at common law is lex loci. If your marriage is proper where it was entered into, it's proper everywhere. The flip side is if it was not validly entered into, it's invalid everywhere. Now, on top of this common law notion of lex loci, we also have the Constitution of the United States of America and something that we call the Full Faith and Credit Clause. Now, the first part of the Full Faith and Credit Clause says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Okay, there is a public record in Pennsylvania that on August whatever, 1978, Robert Raines married Andrea Jacobson. It is a public record. If we focus on this part of the Full Faith and Credit Clause, it would appear that as a matter of constitutional mandate, every other state is bound to recognize a valid marriage, a public record, in every other state. If we just focus on this part of the Full Faith and Credit Clause, then you would think it's a slam dunk that DOMA is unconstitutional. And of course, as I think you know, under the American system with our Supreme Court, if our courts rule that a statute is unconstitutional, then the statute is no longer enforceable. But there's a little bit more to the Full Faith and Credit Clause. The second half says, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved. Okay, fair enough. And the effect thereof. And the effect thereof. Now, that last phrase is what Congress is hanging its hat on in enacting DOMA. Because the people who supported DOMA said, well, we have a right to say what the effects are. And in DOMA, we're just saying it's not necessarily binding in every other state, a same-sex marriage. Is DOMA constitutional? I don't know. Whole portions of the Brazilian rainforest have been deforested, with law professors writing articles pro and con as to whether DOMA is constitutional or unconstitutional. There is only one lower federal court case directly on point. It was decided by a district judge in Florida. It's called Wilson versus Ake. And Judge Moody says the DOMA is constitutional. The plaintiffs in that case chose not to take that case further up the line. So at this point, all we have is a district court decision. That's by no means the final word. Okay, a little bit more background on American family law. We have the brilliantly named case of Loving versus Virginia. By the way, I am from Virginia. When I grew up in Virginia, a marriage between a black person and a white person was not only void, it was criminal. At the time that Loving versus Virginia went to the United States Supreme Court, there were still 16 mostly southern states that still had what were known as the miscegenation or anti-miscegenation laws that made marriages between a white person and a non-white person void, and in Virginia's case, criminal. There was a couple, a white man and a woman who's described in the parlance of the time as a Negro woman, residents of Virginia. They fall in love, they decide to get married. They can't get married in Virginia. So they do what we do in the United States, go somewhere else. They go to Washington, D.C., which, if you know your geography, is just across the Potomac River. They get married. Perfectly legal in Washington, D.C. for them to get married. Had they stayed in Washington, D.C., presumably they would have lived happily ever after. But they longed for old Virginia. And they returned to Virginia, where they were arrested in their home in the middle of the night, taken off in handcuffs, tried and convicted of the crime of miscegenation. They were sentenced to imprisonment for their criminal activity. That case went up to the United States Supreme Court. And in 1967, the Supreme Court of the United States said, this is unconstitutional. It violates the Equal Protection Clause and the Due Process Clause of the United States Constitution, and strikes down their conviction and strikes down the anti-miscegenation law. Now, the court could have addressed this as a full faith and credit clause matter. They were validly married in D.C. Did Virginia have to recognize that marriage under the full faith and credit clause? Well, that was not the issue on which the case was litigated, so the court never decided that issue. By the way, if Barack Obama's parents had tried to get married when they did, in my home state of Virginia, they could not have gotten married, and if they had moved there as a married couple, they too could have been criminally prosecuted, just as the Lovings were criminally prosecuted. Now, what has happened post-Bear? We have a totally fractured response from the states. As of now, and I have to preface this with as of now, we have 5 states plus the District of Columbia. You may know that Washington, D.C. is technically not a state, which permit same-sex marriage by name. Okay, we have Massachusetts, Connecticut, Virginia, Iowa. It's very strange if you know your geography. New Hampshire, and Washington, D.C. These are the same-sex marriage states as of now in the United States. Then we have the state where everything is always different, California. For roughly 6 months in 2008, California permitted same-sex marriage. During that time, roughly 16,000 same-sex couples got married. But then there was a proposition put on the ballot in California called Proposition 8, because it was number 8 of that year, that was put to the good voters of California as to whether to continue to allow same-sex marriage in California. And Proposition 8 was enacted terminating same-sex marriages in California. Now, the California Supreme Court has upheld the constitutionality of Proposition 8, saying that the people had the right to make that vote, but also ruled that all of those same-sex marriages that had taken place remained valid. Proposition 8 is currently in federal court where it has been challenged. The trial court judge says it's unconstitutional, and that case is currently on appeal to our Federal Circuit Court of Appeals for the Ninth Circuit. The case is Perry versus Schwarzenegger. I believe most of you probably know who Mr. Schwarzenegger is. He was a movie star before he went into politics. Okay. Now we have what I call our quasi-same-sex marriage states, and these are states, I think, fairly similar to Great Britain, which allows same-sex couples to enter into a status that smells like marriage, sounds like marriage, is pretty much marriage in all but name. It might be called civil unions, domestic partnerships, different names in different states. And these are Hawaii, New Jersey, California, Nevada, Oregon. Illinois has passed a law. It's going to go into effect in June. So these states have not gone the whole way to allowing same-sex marriage, but pretty far. Now, we have a couple of states that say, okay, we're not going to allow same-sex marriage, but at least for certain purposes, we'll recognize a same-sex marriage from another state. You can add to that list maybe New Mexico, maybe not, but I don't think we need to get into that right now. Now we have the vast majority of states. Roughly 40 states are called the mini DOMA states, or the state DOMA states. These are states which have enacted a state law and or constitutional amendment saying that marriage is only between a man and a woman, and we will not recognize a same-sex marriage from any other jurisdiction, even if it was validly entered into in that jurisdiction. So the vast majority of American states say we won't have it here and we won't recognize it from somewhere else. I live and work in a mini DOMA state. Here's the statute in Pennsylvania. A marriage between persons of the same sex, which was entered into in another state or foreign jurisdiction, even if valid were entered into, shall be void in this Commonwealth. Clear, direct, declaratory sentence. As statutes go, it's clear. You may not like it, but it's clear. Pennsylvania says, this is our public policy. We will not recognize a same-sex marriage. Okay. We'll come back to Pennsylvania, I promise you. Now, there's some pretty arcane law, and I'm not going to bore you with too much of it, about interstate marriages and divorces in general. But let me tell you the sad story of O.B. and Lily Williams. O.B. and Lily Williams both lived in North Carolina. And they were both married, albeit to other people, in North Carolina. But they traveled together, and can anybody guess what state they traveled to try to get quickie divorces from their respective spouses? Anyone on top of this? Come on, you can do it. Nevada. They go to Nevada. Of course they go to Nevada, where they stay just long enough to get divorces from their respective spouses. And the same day that Lily gets her divorce, she and O.B. get married. As far as Nevada is concerned, they are a happily married couple. And like the Lovings, if they had only stayed put, they presumably would have lived happily ever after. Now, in those divorces, they satisfied Nevada that they met Nevada's domiciliary requirements to get a divorce. They provided substituted service, that is to say, that their spouses were not physically served within the state of Nevada. And Nevada was perfectly happy. Unfortunately for Obie and Lily, they did not end up perfectly happy because they made the terrible mistake of going back to North Carolina, where they were prosecuted and convicted of the crime of bigamous cohabitation. Bigamy. North Carolina said, we don't care about your stinking Nevada divorces. They're not valid as far as we're concerned. If they're not valid, your new marriage is not valid. And so you're guilty of the crime of bigamous cohabitation. The case goes to the Supreme Court of the United States the first time in 1942. And the United States Supreme Court chucks out some old rules, chucks in some new rules on interstate marriage and divorce. And basically what the court says is, as long as the plaintiff's spouse seeking a divorce meets that state's domiciliary requirement and provides some kind of service on the defendant, then the forum state, that's Nevada, can apply its own substantive divorce law, and that divorce is entitled to full faith and credit in every other state. And this creates what we call in the United States the notion of migratory divorce. You go where you can get a divorce faster, cheaper. That's what people do. Now, you would have thought Obie and Lily would be okay, except the court remanded the case to allow North Carolina to take another look at whether Obie and Lily really did meet Nevada's domiciliary requirements. And guess what? They're convicted again. And the North Carolina jury said, yeah, they weren't really domiciled in Nevada. They just went there to get a quickie divorce. They never intended to stay there. They returned to North Carolina right away. And the Supreme Court of the United States upheld the convictions this time and said, well, Nevada court's finding that they met the domiciliary requirement is entitled to weight and more, but it can't be binding on North Carolina. North Carolina was in its rights not to give full faith and credit to that finding. Now, where does this leave Obie and Lily? Well, one place it leaves them is in jail in North Carolina. Think about their legal status. Nevada says Obie and Lily are married to each other. North Carolina says Obie and Lily are each still married to their original spouses. How can that be? That's where the story of Obie and Lily ends. That's where we leave Obie and Lily, who probably are no longer in jail since this happened in the 1940s. Okay. Real quickly, this could become important, but we're not going to have time for it. There are two later cases of the U.S. Supreme Court that are quite important in the full faith and credit clause area. Both of them involve unhappy spouses who go to the state of Nevada to get divorces. Unfortunately for them, the state where the other spouse lives says, well, that's fine, we'll recognize your divorce, but your spouse can still go after you for what you guys call maintenance, what we generally call alimony. Now, wait a second. And the first case involved New York. New York says, okay, we understand that you're divorced and we can't do anything about that because of Williams, but that doesn't mean that you could block your wife's financial rights. And in two cases, Eston and Vanderbilt, the Supreme Court agreed with that and said just because Nevada can grant you the quickie divorce, and here they met the domiciliary requirements, doesn't mean they can extinguish your spouse's financial rights without personal jurisdiction over the spouse. And that creates the doctrine that we know as divisible divorce. One state does the divorce, and the other state has to take care of the financials. Okay, back to the main event. What happens when you have a same-sex couple who get married in a state like Massachusetts perfectly legally? Maybe they lived in Massachusetts when they got married. More likely, they live in a state that won't allow them to get married, so they go off to Massachusetts and they get married. And now one or both of them returns to a mini DOMA state, which is the majority of states, a state that says, we don't recognize same-sex marriage. And just as happens with heterosexual couples, with homosexual couples, sometimes love flies out the door after some period of time, and people want to make a legal exit from their status. What happens to people in that situation? Well, now there are a handful of cases from around the United States, including a quite recent one from late 2010 by a trial-level court in Pennsylvania. Two women, not clear where they resided at the time, Carol and Robin, get married in Massachusetts. Sometime later, Carol is back in Pennsylvania, and she says, I don't want to be married to Robin anymore. And there's no question that she meets Pennsylvania's domiciliary requirement to get a divorce. Right? Which, by the way, in Pennsylvania is 6 months. You live in Pennsylvania 6 months, will get you a divorce. Okay. She files for divorce in Pennsylvania. And she serves Robin, and Robin does not defend. Presumably, Robin is just as sick of Carol as Carol is sick of Robin. So we have an uncontested, simple divorce, no custody problems, no child problems, no financial problems. Carol says, all I want is out. I just want to be out of this marriage. And the trial judge says, well, I'd love to help you out, lady. But in order to get divorced, stick with me on this, you have to be married. And we do not recognize that you're married. And our divorce statute only gives the court jurisdiction to get you divorced from a marriage. And since you're not in a marriage that we recognize, I can't give you a divorce. So too bad for you. Now the court kind of throws a little sop to her at the end of the case. Says, but, if you ask for one, we might give you a declaratory judgment of annulment saying that your marriage is void as against public policy. But that's a problem, ladies and gentlemen. If she got a divorce, then under Williams 1, everybody remembers Williams 1, that divorce would be entitled to full faith and credit in every state. She would be free, legally single in every state to go about her business as she wished. But if all she got was a declaratory judgment of annulment in Pennsylvania that said, we think that your marriage is void as against public policy because we don't think same-sex couples should be able to be married, then what are the odds that Massachusetts would give that judgment full faith and credit? I'd say the odds are just about zero, since Massachusetts finds that such marriages are perfectly valid. Now, is this case, Kern versus Taney, an outlier? Is this just some crazy trial judge? I've appeared in front of many of them in Pennsylvania. Is this just one crazy trial judge putting angels on the head of a pin? Well, no. Rhode Island. This is the Rhode Island Supreme Court. That's the highest court in Rhode Island. Same thing. Two women get married in Massachusetts. Margaret meets the domiciliary requirements in Rhode Island. She files for divorce. Held. We can't give you a divorce, lady. You're not married. We have no jurisdiction. Too bad for you. And by the way, Massachusetts has a 1-year domiciliary requirement to file for divorce. You have to live there for a full year before you file. So it's a lot easier to go to Massachusetts and get married than to go to Massachusetts and get divorced. Think about what you have to do. You have to go, get a job, get a place to live, etc. So that's not a very practical remedy in most of these situations. Are Pennsylvania and Rhode Island by themselves? No. Oklahoma. 2 women married, this time in Canada, so technically the full faith and credit clause does not apply. Plaintiff sues for divorce in Oklahoma. Here we have, again, this is the highest court in Oklahoma. No jurisdiction. We don't recognize your marriage. We can't give you a divorce. Texas Court of Appeals, same thing. Same thing. Connecticut Court of Appeals, this is from before they permitted same-sex marriage, same thing. All of the final decisions to date in the mini DOMA states have said, we can't help you get out of your same-sex marriage because we don't recognize your same-sex marriage. Now, what is to be done? What is to be done? Now, I go by the old adage, no problem is so big that it cannot be avoided. I don't know if it was truly anonymous. I was too lazy to look it up in a book of quotations. And so now, and with the humility for which I am so justifiably known, allow me to present you with what we call the RAIN solution. The RAIN solution, and I am going to try to justify this, grant uncontested, simple, no-fault divorces without, addressing whether there's a valid marriage. Give me the divorce, Your Honor. Don't worry your pretty little head as to whether I am married or not. Can the RAIN solution work? Well, RAIN says so. Okay, I say so. Don't know how far that will get you in court. Many people, in our fractured society, many people get divorced when there is or there might be a question as to whether they are married. And usually, unless the other party raises the issue and puts it before the court, courts don't inquire into their marital status. One of the things, as you may know, in the United States, law school is graduate school. And so most of my students are 22 to 25 years old. And we have clinical programs where upper-level law students can actually represent indigent people under supervision in court. And as Roger mentioned, one of the things I do is I am the co-director of our family law clinic. Now let me compare and contrast 2 actual cases that I was involved in supervising. Case number 1. Woman comes into the clinic. She's probably in her mid-50s, and she says, I got married 25, 30 years ago in, I don't remember what state, let's just say Nebraska. And my husband left 20, 25 years ago, and I haven't heard from him since. And I don't have any way of contacting him. I don't know any friends or family. I have no idea where he lives. I don't know if he's living or dead. I don't have a clue. And then she says, I got some papers from a lawyer once. They were from another state. I don't remember. It was Iowa or Illinois or Ohio or somewhere. And they looked important, she says. It was something about a divorce. And then she turns to me and says, well, am I divorced? Now, I am a very good lawyer, he said modestly. But one thing I cannot do is interpret documents that I am not allowed to read. And don't you try to do it either if you practice law. So I say to her, well, where are these papers, lady? And she says, I don't know. I lost them a long time ago. Is she divorced? I have no idea whether she's divorced or not. And no way of finding out. And in the United States, we don't have a central registry of marriages and divorces. We could try to search in 50 states. Maybe we could get lucky. Maybe we wouldn't get lucky. So what are we going to do for her? If she wants to be divorced, what are we going to do for her? get her a divorce. We file for a divorce. She meets the domiciliary requirements in Pennsylvania. We serve the defendant by publication, perfectly legal. He doesn't respond. For all I know, he's dead. He probably doesn't read the Cumberland County newspapers for service by publication. The court grants her a divorce. Was she in a valid marriage? I'll never know. And I don't care. And neither did the judge. It was a simple, uncontested divorce, and there's no reason for the judge to worry about whether she's married. Okay. I'll give you another example quickly. We had a case where a couple living in Pennsylvania had gone through a marriage ceremony in New York State. But it appeared that they sort of forgot to get a marriage license. No, there was also a dispute. It was a Hindu ceremony. There was a dispute about what the ceremony was. Well, how could we test whether they were married? We represented the wife, the woman. We sued the husband for divorce. And he defended and said, you can't divorce me. We're not married. And in that situation, quite properly, because it was placed in issue, the court held a hearing, had to address New York state law because of lex loci, and concluded, quite properly in my opinion, because we represented the wife, that despite the defect of the lack of a license, they were in fact married. So in the one situation, we have an uncontested divorce where the issue is not raised, and maybe they weren't married, and the court doesn't worry about it. And in the second case, okay, there was an issue, and so it was quite proper for the court to worry about it. So remember, the Rain solution is where it's uncontested. Where it's uncontested, the court simply should not worry about whether the parties are validly married. In the mini DOMA state, just go straight to issuing a divorce. Now, you might say, it's not real logical to get somebody a divorce who's not actually married. Okay. But now I'm going to prove to you that there's actually statutory precedent for this, at least in the Commonwealth of Pennsylvania. And now I have to talk about another client. A young woman, maybe mid to late 20s, is married. She comes into our office with a sad story. She got into the family car one day, and she noticed some papers her husband had left on the back seat. We could all get into why he left these papers. Actually, this is similar to the recent movie in Education. She's curious. She picks up the papers and is quite surprised and not altogether happy to read that another woman in another state is suing the man she thinks is her husband for a divorce. He had forgot to tell her about this other woman and the marriage. Okay, now, she wanted out. What are her options? Well, under Pennsylvania statutory law, she's got two options. Option A. Our statute is clear. She could get an annulment, where either party at a marriage is void, bigamous marriages are void, where either party at the time of such marriage had an existing spouse and the former marriage had not been annulled, nor had there been a divorce, except where the party had obtained a decree of presumed death of the former spouse. In English, she was in a void marriage. She could get an annulment. Seems perfectly clear. But in Pennsylvania, it's what we call a dealer's choice. She could get a divorce too, because our divorce section of the Domestic Relations Code says a court may grant a divorce to the innocent and injured spouse. By the way, all of our clients are the innocent and injured spouse. Whenever it is judged that the other spouse has knowingly entered into a bigamous marriage while a former marriage is still subsisting. So even though Pennsylvania statute says that marriage is void and subject to annulment, it also says, yeah, she can get a divorce. It's up to her. So there is at least one crazy state, the one that I practice law in, that says you can sure enough get a divorce out of a void marriage. Now, as you already saw from Williams and all that stuff, I was talking about the constitutional right. We say, and Loving, we say there's a constitutional right to marry. How far it goes, anybody's guess. And it's linked to a right to divorce. Think about the Williamses. Okay? No, yeah, think about the Williamses. Their right to be remarried in Nevada was based upon whether they had a right to divorce and whether the divorce was valid. I propose to you that it is important to allow same-sex couples who wish to do so to get divorced, even in many DOMA states, because this is highly pertinent to their right to remarry. Now, what would be the consequences of adopting the Reigns solution? This should make the many DOMA state legislators happy. They passed a law that said we don't recognize any stinking same-sex marriages. By not recognizing the marriage and not letting the person out, that person's still in a same-sex marriage. But if they adopt the Reigns solution, the immediate result is one fewer same-sex marriage. These legislators should be dancing in the street. Now, that's only the short-term, immediate result. What are the possible long-term consequences? Well, the plaintiff may choose to remain single. Many people get out of a marriage and they say, I'm not so sure I ever want to do that again. Does everybody know the definition of a second marriage? The triumph of hope over experience? Okay. That's possible outcome number one. Now, that should certainly make the mini DOMA legislators very happy. Now, we have a second possible outcome. Plaintiff still oriented toward the same sex, goes back to Massachusetts with some other member of his or her sex and gets married there. Okay, as far as I'm concerned, that's a numerically neutral result. There's still one same-sex marriage. Now, you can, of course, play that out and say, well, now the other person might do it too, and on and on and on. But certainly in terms of that plaintiff, you can really only get married to one person at a time in the United States most of the time. So that should be a neutral result. That shouldn't make those state legislators so unhappy. Okay? Possible long-term outcome number three, and this happens. Plaintiff says, great, I'm free to remarry. Now I've met Mr. Right of the opposite sex, or Ms. Right of the opposite sex. I have changed my orientation. I have thought the better of my ways. And now, because you let me out of my same-sex marriage from Massachusetts, now I can lawfully marry a member of the opposite sex right here in Pennsylvania or any other mini DOMA state. And since the politicians who favor these DOMA laws always say that they do it because they favor traditional heterosexual marriage as the cornerstone of democracy and freedom and Christianity and Judeo-Christian ethics and all that stuff, they really should be dancing in the street if this is the outcome. The beauty of the Reigns solution, illogical as it may seem, is it is an effort. I mean, we're not going to resolve this debate in the United States anytime soon. I absolutely guarantee you. That's so not going to happen. People do move from one state to another. The Reigns solution is a way to respect the states that permit same-sex marriage, but also respect that majority of states that do not respect or recognize same-sex marriage and say to them, okay, all right, that's your law, like it or not, that's your law, but resolve the problem this way. You don't have to recognize same-sex marriage, but let people out of them through a divorce. Getting back to Carol in Pennsylvania for just a minute, if she gets an annulment in Pennsylvania and marries a man in Pennsylvania, what happens if she goes on vacation to Cape Cod in Massachusetts with her new husband? What are they going to do to her in Massachusetts? Arrest her for bigamy. But if our court would only give her her uncontested divorce, she can go to Old Cape Cod, as the old song goes. And so that is the Reign solution. No court has adopted it. Don't try this on TV. And we'll see. We'll see what happens. Thank you.